Welcome to this morning's sitting of the First District Court of Appeal here in the First Circuit. We thank Chief Judge Miller and our hosts here in the First Circuit who have laid out the welcome mat for us. It's been a good morning thus far, and we expect that will continue. We have two cases on our docket this morning. We'll take them in the order in which they were printed. The first case, case number 23-1683. Rogers versus Waste Pro of Florida. Appellant's counsel, when you're ready.
How about those are 7 minutes?
Did you say 7?
Yes, Your Honor.
Thank you.
Thank you. May it please the court. The issue that this appeal focuses on is not an injury of back pain or sprain, strain type injuries, soft tissue injuries. It's not about a surgery or radiofrequency ablations or prior accidents. It's specifically about a structural change to a lumbar disc, the L5-S1 level. This is a case in which all of the medical experts, of which there were numerous, Drs. Mahan, Dr. Giovannini, Montgomery, Anderson, and Dr. Stetzel, all agreed that an MRI taken 2 months following a car accident showed a change, a structural change, when compared to an MRI that was taken approximately 6 to 7 months prior to the car accident. In this case, although Dr. Stetzel's deposition testimony was played in appellant's case in chief, he was a physician, an expert retained by the appellee. And Dr. Stetzel's testimony was that the appellant suffered an injury, and that injury was an exacerbation, a temporary worsening to her lumbar disc.
Right, and he never said there was a permanent worsening, did he?
Correct, Your Honor, yes. And we believe that was addressed in the motion for directed verdict, where directed verdict was not requested on the issue of permanency, just upon the issue of an injury itself.
And isn't it true that the jury would be free to reject even uncontroverted expert testimony if there was lay testimony and other testimony in the record, even by the plaintiff, which may have conflicted at times? It wouldn't matter if that Stetzel testimony was uncontradicted, would it?
No, Your Honor. I believe that would be correct if the contradictory testimony in the record was in direct conflict with the issue of an exacerbation of the L5-S1 disc.
Well, and let's talk about that then. So it's my understanding of the record that this was the plaintiff's 7th car accident in 12 years. Is that right?
Yes, Your Honor.
All right. And year prior, there had been 2 prior collisions in the last 2 years. One with a head-on collision and another one with a rear end injury, correct?
Yes, Your Honor.
All right, and in both of those cases, there was an injury to the L5-S1, which is the issue that you brought forward in the motion for new trial directed verdict.
Yes, Your Honor.
All right, so the lay testimony, there's plenty of lay testimony that would contradict exacerbation, right? So the plaintiff didn't complain of any pain at the date of the injury, 2 days later the colonoscopy, and the record also shows that she was on 16-hour flights to Thailand, to Morocco, riding camels, elephants, lifting weights. Is that not enough to contradict the expert testimony of the temporary aggravation of this injury?
I would suggest, Your Honor, that she had been involved in the 2 prior accidents, both of which were significant. She then had an MRI that was performed in December, and the MRI findings in December were markedly different than the MRI findings the following September after the car accident issue in this case. The arguments that were raised about the onset of pain and her complaints to the colonoscopy, which actually the following morning, not 2 days later, those were never directly tied to an exacerbation to an L5-S1 disc. Dr. Stetzel testified that an exacerbated disc or a herniated disc even doesn't necessarily manifest itself in pain.
Right, so the jury was supposed to put blinders on as to all of that and focus only on the fact that there was a medical expert who was testifying as to a temporary aggravation of an injury. Again, that this plaintiff had a spinal surgery on that exact area, L5-S1, November 16, and again had a and let's talk about the car accident here. How many miles per hour was the car estimated to have been traveling when there was a collision?
I believe it was approximately 5 miles an hour to 7 miles an hour on the video.
Right, and there was testimony that an object on the dash didn't even move during the impact on the injury in this case, is that right?
A pen, yes, Your Honor.
Right, was that something the jury could consider in terms of the causation, again, collectively with the plaintiff's conduct and statements after the collision?
I would say the difficulty with that is that it would require some correlation between all of those circumstances and the ability to exacerbate a pre-existing degenerative condition in the L5-S1 spine. And so while there were conversations about that, there was no biomechanical evidence in this case. Dr. Stetzel, who testified, did review the video. But as far as the jury's ability to disregard that, I would suggest that there was nothing in the record before it to suggest that that was a reasonable inference, specifically with regard to the structural change to a lumbar disc.
And Dr. Stetzel did not watch the video, correct?
My understanding is that he did have
He
that.
did, okay.
And
So-
within a day or two after, plaintiff had I believe it was previously scheduled doctor appointment where she reported a 0 out of 10 pain.
Yes, Your Honor,
With
it's
the
actually the
accident.
following morning, a colonoscopy, yes. With the complaints of pain the following morning, with the speed of the accident, all of those, with regards to a generalized complaint of low back pain or a soft tissue injury, subjective complaints like that, I would suggest that a jury can draw reasonable inferences. Ours, though, was specifically targeted towards a structural change to a lumbar disc. And there was never any connection made between the severity of an impact or the pain the following day and whether or not structurally the lumbar disc can be changed.
Was there ever any testimony, though, as to a permanent change to that disc following the 2018 injury? Or
Yes.
collision?
Apologies. Yes, however, that was disputed. Dr. Stetzel did not say that. Dr. Stetzel's testimony was that it resolved approximately by March when she had a subsequent MRI done. Dr. Giovannini and Dr. Montgomery both testified that it was a permanent injury from the car accident. However, that was not raised as part of the motion for directed verdict.
And again, let's talk about some of the other testimony. The plaintiff's own testimony conflicted, right? In her deposition, she said she had no pain after the accident, or maybe I have that backwards. One time she said she did immediately after the accident, then she didn't.
Yes.
She was questioned about whether she was lifting weights 4 days a week and exercising on a treadmill in a doctor's visit about 3 months after the accident. And again, she didn't recall that, although that information was recorded in medical notes, right? So there's some issues with the plaintiff's credibility, correct?
Agreed. Yes, ma'am.
Right, and that same kind of report were the kind of reports she was giving to the doctors who are reaching these medical conclusions.
Yes, Your Honor, and I would suggest that that goes towards the pain, the suffering, the severity of an injury, whatever that may be. And if she had made a claim for either a soft tissue injury or the surgery or pain management, all of that testimony would have been, I think, directly relevant to contradicting those claims as it was.
Wouldn't it be fair, though, to say that at best, Dr. Stetzel's testimony could have supported damages for a temporary injury that resolved itself within a few months, at best?
I would suggest that Dr. Stetzel's testimony at best was that she suffered an injury from the accident that resolved. But
That resolved.
yes,
That
that's,
resolved by March, right?
yes, sir.
All right, and he also understood that there were, again, 7 prior car accidents and 2 surgeries in the 2 years prior.
Yes.
Right, okay.
But as to his testimony regarding the limited scope of the motion for directed verdict in the trial was that there was an injury to the lumbar disc. And I think the Broward versus Zogan case, which talks about allowing juries to determine inferences from unproven allegations, is central to the issue here. Again, there are, as Appelli pointed out in their brief, there are countless instances of inconsistencies in either the testimony or her activities afterwards, which could be used to to prove that she's engaging in activities such as the flights, which will be similar to what the court found in Lancheros versus Burke. But all of those, again, there's no testimony before the jury or the trial court that any of those were relevant to whether or not the car accident caused a structural change to the disc. And
Wasn't there testimony that the injury could have been caused by other things, like even sneezing or exercise and things like that?
Your Honor, my recollection of the testimony was that a herniated disc could be caused by those, by sneezing or lifting weights. The ultimate question, though, was with this particular disc herniation, was or could this disc herniation have been caused by sneezing or lifting weights? And those questions were never asked.
Isn't that a reasonable inference for the jury to make, though, that they received testimony that this kind of injury could occur from sneezing or from other lifestyle choices, other exercise, aging, things like that? Isn't it a reasonable inference for them to hear that testimony and then go, okay, well, based on what we have here, there's multiple ways that this injury could have occurred?
I would suggest, Your Honor, that it would be a reasonable inference if a medical expert had testified that this particular herniation could have in fact been caused by those activities. But that question was never asked to Dr. Stetzel or to any of the other doctors. And so...
But did it need to be, and you're familiar with Wall v. Granger, I think that was cited in both briefs, right? So
Yes, ma'am.
the Supreme Court in that case said that when a medical expert's opinion is predicated on incomplete or inaccurate medical history, the jury is free to reject the expert medical testimony even without conflicting medical testimony, if there's conflicting lay testimony. What does that mean to you, and how does that apply to this case?
So I believe the way that should apply, Your Honor, is that the conflicting lay testimony when we're dealing with a structural change to an MRI needs to be specifically tied to the way in which that lumbar disc can be damaged and can present itself afterwards. And the lay testimony, when somebody talks about, in Wall v. Granger, it was the hip injury that everybody agreed existed. But in this particular case, I would say that the injury is more like, excuse me, more like the aneurysm in Campbell versus Griffith, where there was a question about the delayed onset in that presentation. But an aneurysm is a very specific, it's not a nebulous concept.
Sure, and I think just, but getting back to what the Supreme Court said in Wald, you know, if there's incomplete or inaccurate medical history, and you can see there was some of that here, right?
Yes.
And you also would concede that there's some lay testimony that would conflict with the doctor's diagnosis that this 2018 injury was the main cause of any, you know, exacerbation for the plaintiff. So why wouldn't Wald resolve this case and allow this to go to the jury?
Because the testimony that was presented on either an inaccurate or an incomplete medical history had to do with her representations of pain following the accident. But there was nothing to say that inaccurate or incomplete medical history was relevant to the issue of a herniated or exacerbated lumbar disc. And that would be the distinction, Your Honor, in our opinion, is that yes, you can have those, but the question is it relevant to the specific issue claimed? Thank you. I'll reserve the rest of my time.
Thank you, Counsel.
May it please the court, I'm Chip George, and it's good to be here. I represent Waste Pro, and I'd like to point out that I think the appellant has the burden of proof mixed up in this case, because the burden of proof is no longer whether or not the jury decided properly by the preponderance of evidence. The burden of proof on this appeal is whether or not a directed verdict was proper and a new trial was required because the jury's verdict was against the manifest weight of the evidence. In order for the jury's verdict to be against the manifest weight of the evidence, plaintiff has the obligation, not me, they have the obligation of showing that there were no facts from which a reasonable jury could reach their decision. And as Your Honor properly pointed out, the evidence was in conflict. It was in extreme conflict. And because it was, because it was, this court has to affirm. Because we're no longer deciding, you're not sitting as super jurors and deciding that, well, you know, the preponderance of the evidence weighs such and such, and maybe they could or maybe they couldn't have believed it. You have to look and say, could no reasonable jury find as they did? And the answer to that is no, because the case law says it clearly. If there's any reasonable facts in the record which support the jury's verdict, the case has to be affirmed. Now let's talk a little bit about.
Let me ask you some questions about that, because I think the narrow question that the appellant raises is, you know, an MRI is an objective measure of structural changes to the spine, right? And there's testimony that there was a change on the MRI between 2016 and 2018 when this accident occurred. And so the only testimony that the appellant is pointing to is that this one expert testified that the 2018 collision was the cause of the exacerbation that you saw in the MRI. And why didn't your client have to present evidence to conflict with that? Isn't all of the discussion of pain and trips to Thailand and Morocco, couldn't that be considered noise as to the pain, but not as to the structural change?
Okay. Plaintiff had an MRI in December of 2017. Our accident occurred in July, early July of 2018. She had another MRI 5 or 6 weeks later in September of 18. And that MRI showed a slight change to a pre-existing condition. And so as a result, plaintiff is saying, must have been an exacerbation. But what plaintiff isn't telling you is this: how did the expert who testified that it was an exacerbation reach their opinion? And the answer to that is, I read the medical records and relied upon plaintiff's subjective complaint after the accident in the medical records, and I put together the objective finding and the subjective complaints and said, it's my opinion that this is what happened. Now, that's fine, except for the fact that, as you know, the case law is clear on this, where the plaintiff's veracity is called into question, and here it's certainly called into question. She said this happened, and then she told the jury it didn't happen. She said this happened, she told the jury it didn't happen. Your Honor laid it down, I don't need to go into it. Where the plaintiff's veracity is called into question, her medical records and subjective reports are called into question. And when the medical records and the subjective reports are part of the expert's opinion, and clearly that's what's happening here, because looking at the MRI by itself tells the expert nothing.
It doesn't go to going from protrusion to extrusion. That isn't an MRI oriented.
I'm sorry, Your Honor?
My understanding is that your brother's argument is that we went from a herniated disc that was in a state of protrusion to extrusion with the 2018 accident.
The MRI post-accident, like I said, 5-6 weeks post-accident, showed a slight bulge, which later resolved itself. And nobody's really clear how it resolved itself. And that's the objective finding that they're relying on. And now for the expert to say that objective finding is related to the accident in July, 6 weeks earlier, they have to have something. And they kind of took me to task in the brief for not bringing in a biomechanical expert and tie it together, but that wasn't my job. It was their job to tie it together like that. The only thing the expert relied upon was the plaintiff's subjective testimony and subjective description of her problems to her doctors and medical records. So as a result, she has a veracity problem. The jury is entitled, as a matter of law, to look and say, she had a problem here, I'm not sure I believe it there, and so the information the expert's relying on isn't valid. I'm going to reject the expert's findings because I don't believe her. I don't believe that her subjective reports of pain, for instance, a good example hypothetically is rear ender, plaintiff doesn't go to the doctor for 6 weeks. 6 weeks later goes into the doctor and says, my back's killing me. And the doctor says, what happened? I was in a car accident. My back started hurting me immediately afterwards. Well, the jury has to decide was the 6 weeks between going to the doctor and the accident important or was it not important? Is that subjective complaint that it happened because of the accident true or not true? And it's strictly in the province of the jury to make that decision. And then from there, because we instruct them, you can accept the opinion, reject it, or give it the way you want.
All right, and so let's go back to the opinion. So I want to figure out where you agree. So you agree with the appellant that the MRI did show a change, right? In September of 2018, there was a slight change, but you agree, you concede that, correct?
The MRI showed a slight exacerbation, yes.
And so we're talking about only causation, and so it would have been important to Dr. Stetzel's evaluation to know that between July 18, when the collision occurred, and September 18, that's when she was on the 16-hour flight. That's when she was riding camels and mules and all of the things. So those are things that the jury could consider as possible causative factors for the exacerbation.
The jury certainly could have considered the medical expert's objective, there is a problem, and plaintiff's subjective, my back hurt after the accident, and arrived at their decision and said, yes, there's causation. They could have done that. But they're also entitled to reject it. And that's why I say they have a problem with the burden on this appeal. We cannot go back and decide that the jury's preponderance of the evidence decision, the rejection of the expert's testimony, was improper because there's evidence which support the rejection of the expert's opinion. And the evidence is this: plaintiff wasn't truthful in her testimony. The jury was then entitled to decide that plaintiff wasn't truthful in giving her medical history to a doctor. The jury is then entitled to say that the doctors, the experts who read the MRI, saw the objective, and read the subjective report of, I had pain after the accident, so it must be related. The jury is entitled to reject that as a matter of law. And we're not entitled to talk about the preponderance and whether they got it right. We got to talk about manifest weight. And it's clearly, there's evidence on both sides. This was a jury for the decision. Interestingly,
So you would concede that if the jury had come out the other way, that you wouldn't be able to bring this appeal?
they could have decided the other way you are.
Right, and you couldn't come in and say the manifest weight was against that verdict?
That's the problem with veracity questions in situations like this. It's kind of a paradox. Were you telling the truth then? Are you telling the truth now? Do you tell the truth at all? We leave it to the jury. Because they're the ones that are sitting there and they're making the decision. They're deciding whether or not the person is credible, they believe the testimony, they don't believe the testimony. And that's the paradox we ran into here. I'd like to point out that Dr. Mahan, their own expert, who gave the opinion that it was connected, actually kind of impeached himself. I thought I had it up front, I don't have it, I apologize. Dr. Mahan in the record said, I believe it's causally connected, but then he said, at page 290, 291, I cannot tell you whether or not the herniated disc, in this case, is a symptom of the accident because I didn't objectively talk to the plaintiff. I didn't evaluate her. I'm working from her medical records, is what he told the jury. So he told the jury it's causally connected, but then he kind of impeached himself by saying, but I can't tell you if it's really connected because I didn't see her, I didn't do a clinical study on her. As a result, the jury was allowed to look at it and say, okay, he's trusting what she said, we don't trust what she said, I'm rejecting what he said. The same thing is true with Dr. Stozel. Dr. Stozel said, that's page 311, 312 of the record, the first thing he said when he's in his deposition is, I'm relying on plaintiff's medical records as well as my review of the MRI documents and so on. So his testimony and his opinion is also based on plaintiff's subjective complaints after the accident. Now we know, for instance, there's a lot of problems with her subjective complaint. She didn't tell her surgeon about the 2000 accident at all, 2018 accident. She didn't tell him. What she did is she told him about the 2016 and 2017. Prior to our accident, he recommended surgery. Subsequent to our accident, he did surgery. And his medical records actually show that he was billing he was billing based upon the 2017 accident. This is all on the record. Ironically, he then got to trial, a doctor operating on a patient under a letter of protection. He got to trial and he gave a causation opinion saying the 2018 accident caused this injury. How can he do that? He never knew about it. It's not in his records. He was billing for treatment for a different accident. The record's replete with conflicts like this. The record is replete. The jury had plenty of information in front of it which could show it that there was a different means of causation. For instance, her own doctor, Dr. Montgomery, who says, I think it's causally related. Well, why is that? Because she told me so. That's what Dr. Montgomery said. And I got record citations for all this in my brief. That was 572. She said it was true, so I took it as true, page 572. Dr. Montgomery couldn't say objectively that the two were related. The jury couldn't rely on that. Well, they say, well, there's no evidence of any other cause. Well, there is evidence, as you know, and you pointed out, Your Honor. It was a low-speed accident. There was a pen-like structure on, I think it was a chapstick, on her dashboard. And guess what? Her video of the accident, it didn't roll off. That's how slight an accident was. The jury saw that. She walked around at the scene, told everybody everything was fine, I'm okay. People stopped and said, are you all right? Well, I'm fine, thank you. Drove her car, picked up her daughter, went home, went the next morning to a different treater for a different problem, and told him, I have zero pain. The jury could find. There's evidence. The last thing I want to point out is this. She told her chiropractor that she was working out 4 times a week, doing treadmill and weights and so on. She's getting back in shape, and she was really excited about it. Told the jury, I couldn't work out after the accident. Guess what? Wrong. She told the jury later on cross-exam, well, yeah, I could work out. Didn't bother to tell her doctor that. But what did Dr. Montgomery say? Dr. Montgomery said, yes, physical exercise like lifting weights and working out can cause exactly that type of problem. There was a lot there for the jury. And the jury properly decided. They could have gone one way, they could have gone the other. I could be in that seat instead of him. We have to affirm because the jury made the decision, and we can't sit here as super jurors. Thank you.
Thank you, Mr. George. Rebuttal.
The example that counsel used about an individual who gets involved in a car accident, there's a 6-week gap of treatment, and then shows up complaining of back pain. Arguments like that, I think a jury could fairly look at that gap and question whether or not a person was injured or the severity of it. Dr. Stetzel testified to 2 things, though, and only one of them was a basis on this appeal. Dr. Stetzel testified that she could have had a lumbar sprain or strain, or very likely did. And that was at page 344 of his transcript. But that's a separate issue than a structural change to the lumbar disc. Dr. Mahan's testimony was very specific. He testified that she had an acute change on the 2018 MRI. What he testified to, and this was at page 290, was that he didn't know whether or not that herniating disc was causing her symptoms, not whether or not it was caused by the car accident. And that's when Dr. Mahan testified that clinical correlation would be necessary. Therein is, I think, the piece that was missing that didn't allow any reasonable inferences in this case, was that there should be a way in which an exacerbated lumbar disc presents itself, so that all of this noise about inconsistent pain complaints, differing reports to her doctors, those are all incredibly relevant to the extent of an injury, that concept. But as to the lumbar disc itself, that was never tied together.
Well, that's fair enough, but again, if we're really, the real disputed issue here is causation, right? Causation between July 18 and September 18. And is it incredibly relevant again, these 16-hour flights, the exercise, the camel riding, all of that, would that not be relevant to the jury determining whether we believe the expert who ties causation for that MRI change to this low-speed accident versus maybe, getting on a plane? Maybe, why isn't that proper for the jury to resolve?
And I will apologize in advance. As I sit here right now, I do not recall the date of those trips overseas in camel riding, whether or not that took place between the July accident and the September MRI.
I think that it's, if you look at the transcript at 6:43, it may answer that question.
Thank you. What I would say is, again, those are all relevant examples of a way in which a jury could question the severity of an injury from an accident. But the question would be, is it reasonable for a jury to conclude that a person who has an exacerbation to an underlying degenerative condition in their lumbar spine cannot do those things but for a car accident? Or that because they participate in those things, it means that the lumbar disc was not exacerbated as a result of a car accident? And there was, at this point, we're guessing. Just like we're having a conversation about whether or not the pen falling off the dash or a low-speed accident is relevant to whether or not there was sufficient force to exacerbate a degenerative lumbar disc. There was no biomechanical testimony of that. And there's nothing in the medical evidence that was offered by any of the experts to suggest that that would be the case. And there's nothing in the record to suggest that an exacerbation to a lumbar disc requires an individual to complain of pain within a certain set time frame. And so all of those are, again, excellent cross-examination and impeachment of the appellant in this case. But they attack a different aspect of the case. They do not go to the issue of whether or not the lumbar disc, which all the medical experts agree was exacerbated as a result of the accident. They don't go to that specific issue. And so under the standard, I don't believe that that type of argument raised is direct conflict with the medical testimony from the experts. Looking at that, it was an abuse of discretion, and it's against the manifest weight of the evidence with specific regard to an exacerbation to a lumbar disc as a result of the accident. There was no dispute amongst any of the experts, the only folks who were qualified to testify in the first place, as to whether or not that occurred. So, thank you very much.
Thank you.